corruptly, and I'll just say a little bit about that, giving or offering anything of value, and we'll talk a lot about anything of value, to a foreign government official. And you have to understand that a foreign government official in this context is not just the regulator or a legislator or a minister, but any person who is an employee of a government-owned enterprise or a government agency or a government commission can be considered for these purposes a government official. And that's either the payment's made directly or the offer is direct, or it's indirect with knowledge, and we'll talk about what that knowledge element is, to influence or secure an improper advantage related to your business, to obtain or retain business. Now, the principal risk areas I want to talk about in the limited time here is there are a number of commercial practices that companies have which are fine, but once you are involved with a foreign government official or an employee of a state-owned enterprise or a government-sponsored commission where those members of the commission, the DOJ, it doesn't really matter what the foreign government's law is, although we would argue that should be considered. It's what DOJ considers to be a foreign government official. Then you have to act with extreme caution. We'll identify a few of those areas. And then secondly is the responsibility you have for your intermediaries, and that goes back to the element of when the payment is done indirectly, you pay an intermediary, be that a consultant, be it a broker, be it whomever, and you have some level of knowledge that they are going to make an improper payment. So the anything of value. The big issues that come up in this area, and I'm sure affect your industry as well, is you want to sponsor a seminar like this one, and you want to have a government speaker there, or you want government people to attend, and so you want to pay their way. The question then is, can you do that? There are some advisory opinions that the Department of Justice has issued. There are ways to do that lawfully, but there are also ways to do that illegally. Commissions, scholarships, charitable donations. This is a big area in the health and medical device area. They're constantly being requested to make contributions to public hospitals or the like. Can be perfectly innocent, can be a serious problem if that happens to be the personal charity or the favorite charity of the person who regulates, as was the case for shearing plow in Poland. It was the person who approved particular drugs for sale in that country, their favorite charity. So in fact, the government was taking the position that was a benefit to that official by making the charitable contribution to a third party. There are a variety of payments which are not covered, and facilitation is an express exemption in the statute. What you have to realize about facilitation, the concept was, well, there are a number of small payments, expediters, you have to get something done. I need a work visa, and I've got someone coming to go into that country, and I've got to get it within 3 months, but they're telling me it's going to take 6. But if I pay a few dollars, I can get it in 2 days. Is that okay or not? The basic rule of thumb is that it has to be a ministerial act. You can't be purchasing the process, get the person to approve something that they have discretion to approve or not approve, or that you're not entitled to. But if you are entitled to it and the payment is solely to ensure that the person does it, then it can meet this exception. DOJ does not believe this exception exists, and they have entered into some deferred prosecution agreements and non-pros agreements after disclosure, in each of these cases with significant fines. The Wabeck case was in India. It was paying to expedite various shipments. In AGA Medical, it was to expedite issuance of a patent. In both instances, DOJ went and said that was beyond facilitation as it's narrowly defined. When the OECD convention came out, it originally said facilitation is not a bribe. That's not within the improper payments as that was used in the convention. More recently, in 2009, they issued guidance saying, nonetheless, companies should prohibit this and encourage countries to take action against it because